We'll watch this because there's a meter.
Good morning, everyone. Welcome to day 3 of the Norman Manley Law School's Legal Aid Fair. My name is Trevor Cuff, and it is my pleasure to be your host and facilitator this morning. Today's session promises to be a practical and informative session. And if you had a look at the schedule before, you would be aware that it is titled New Year, New Look, Expungement of Criminal Records. And to present on this topic, we have Detective Sergeant Leston Ferguson, who is assigned to the Technical Services Division or the Criminal Records Division of the Jamaica Constabulary Force. And he has direct responsibility for criminal records management. Now, I want us to give Mr. Ferguson our keenest attention as he has served in the force for over 25 years, having enlisted on December 3, 1990. And during his career in general policing and criminal investigations, he has gained the respect of his peers, both internationally and locally. And he's a disciplined worker that gets along with his juniors, his seniors, and he's highly motivated and aspires for outstanding achievements in the field of his duty. At this point, I will hand over to Detective Sergeant Ferguson so that he can further edify us on this topic.
Thank you very much, Mr. Cuff. Well, those online, you're reminded that you can place your questions in the chat and we will get to them at the end of the presentation. Right. So, morning, we'll be having a discussion on records creation as well as the expungement process. And let me, before I get into the presentation, let me say thank you for that introduction, Mr. Cuff, and also that the Criminal Records Office is that arm of the Jamaica Constabulary Force that is given the awesome responsibility of keeping a record of criminal convictions in Jamaica. Also, keep a record of convicted persons convicted outside of Jamaica once we have their fingerprints and the details of their convictions. And this is authorized by law. The Criminal Records Office or the Jamaica Constabulary Force gets its authority to keep records from the Criminal Records Rehabilitation of Offenders Act, the Criminal Justice Administration Act, and force orders. Before we get into the creation of the criminal record, we will look at a few definitions. First one we will look at is crime. The basic notes of the Jamaica Constitution full screen.
Good morning again, folks. We apologize for the brief break in transmission, and we ask that you bear with us while we resolve some technical difficulties on our end.
I thought all of that was set up. Apologize for technical difficulties, and just let me know if you were hearing what I was saying earlier. I have a feedback from you.
Yes, sir, Ferguson. We were hearing you quite clearly.
Okay, so I can just continue.
Yes, please.
Right, so we'll look at a few definitions, and first one is crime. And the training notes of the Jamaica Constabulary Force define crime as a legal wrong, remedy for which is punishment of the offender by the state. And I'm certain that the audience would be aware of crimes like larceny, which is stealing, rape, murder, illegal possession of firearm, unlawful wounding, assault, and so on. I think that issue has been fixed now. Another definition is arrest. And the basic notes define arrest as the restraining of a person from his or her liberty by apprehension or taken into custody. So if a person is told by the police to remain in a particular position or in a particular location, he has been arrested because he does not have the freedom to move from one place to the other. There's a charge. A charge is where a person is accused by a reasonable person of having committed a crime. And a reasonable person could be a police officer, a person who feels that they have been wronged by the accused person. And that person would be of credible character. And we move on to another, which is conviction. And the Criminal Records Rehabilitation of Offenders Act define conviction as including any findings in any criminal proceedings or proceedings under the Child Care and Protection Act that an offense has been committed by a person. So if a person is charged with an offense or a crime, he's brought before the court and he pleads guilty, that is a finding of guilt. Therefore, he has been convicted. If, however, the person pleads not guilty and the matter goes to trial, the judge or the jury finds the person guilty, then that is a conviction. Now, having been convicted, the person has to be sentenced. The court has to punish the person in some way or another. And the Criminal Records Rehabilitation of Offenders Act defines a sentence as including any order, not being an order dismissing the case made by a court with respect to a conviction and directing anything to be done or not to be done by the offender. So the person appearing before the court pleads guilty. The court accepts the plea and decides to impose a punishment. Punishment can either be a fine, an alternative of imprisonment. Person can be admonished and discharged. Persons call this a road sentence, and this is where the judge will say to the person, do not do it again. You have been convicted, but do not do it again. And they are set free. The offender can be asked to provide free labor to the state in the form of community service, and this is always meted out in hours. The person can be incarcerated. The person can be sent to prison from 1 day to many years. The person can be bound over to keep the peace, meaning that the person is told to stay out of trouble, do not get convicted again, do not get charged again. And in acceptance of this sentence, the person agrees to pay a particular amount of money if he or she breaches the sentence. This sentence is usually with or without a surety. The person can be given a suspended sentence in that the person is sentenced to imprisonment. However, the sentence is put off for a period of time. And if that person is convicted within that period of time, he or she may be called upon by the court to serve that sentence. The person may be placed on probation, and this is where the person is monitored by the probation officers attached to the Ministry of Justice. I do arrest people. Persons are arrested where the police witness the crime being committed. For instance, there's a point along a popular roadway. Motor vehicle is stopped, properly searched, and a firearm is found in the motor vehicle. The owner of the motor vehicle or the driver of the motor vehicle is not a legal owner of a firearm. Therefore, he would be arrested and charged with illegal possession of firearm. And so is it with maybe drugs, illegal drugs, or any other contraband. Another way that a person may be brought before the court is where a third person attend the police station or inform the policeman on beat duty that someone did them wrong. It could be a case where there was a fight, somebody got wounded, or somebody got beaten up, so he suffers bruises and scratches. So he reports to the police that he was beaten up or he was wounded by a person. He gives a statement to the police. The police go in search of the accused person, arrest and charge them. However, the person giving the statement must be a credible witness, in that his word can be relied on. And go into the arrest process further. Now, as soon as a person is taken into custody, police has a duty of completing a profile form for the person. That profile form, it is called a CR12 by us. The person doing the arrest can complete the form, or you could direct someone else to complete the form on his or her behalf. And the form will tell the person's name, his age, date of birth, address. It will tell who his parents are. Also take a telephone number, physical direct description of the person. The form will collect where the offense was committed, the offense, and we collect a brief history of how the offense was committed. This form that you are seeing, this is just page 1 of the form. There's page 2, which is not shown here. Now the CR12 is placed on the case file to be brought to court. And the case file would consist of the witness statement, the policeman's statement, and also any certificates from the lab or from the doctor that may be required based on the nature of the case. Now, the case is brought before the court, and the person is found guilty and sentenced. The court makes a fingerprint order in that the court is telling the police, you can take this man or this woman's fingerprints and record the conviction. So the person before the court, he's found guilty, he's sentenced. The police gets a fingerprint order, and this is where the FP01, which is a fingerprint form, comes into play. The person's fingerprints are rolled onto the form. Person taking the fingerprints signs the bottom of the form, and the date of conviction is recorded there. The person's personal details are also recorded at the top of the form. Also, the nature of the conviction and the sentence. Now, both this form, along with the completed CR12 or profile form, are forwarded to the Criminal Records Office within 10 days of the conviction. Now, all the information on both forms must correspond. Date of conviction on the fingerprints form must correspond with the date of conviction on the CR12. So these forms are received at the Criminal Records Office, and it is our duty to examine these forms to ensure that the information we get is the correct information. The information on both forms correspond, and we log the information. We tell the system that we receive the information. Now, this logging is done electronically on the Cyclops workflow. Cyclops is our electronic database, and I will tell you a little bit about it later on. Now, to establish the identity of the person convicted. And the truest form of identity available to us now is fingerprints, is the fingerprints technology. So we must forward the documents that we receive to the Fingerprints Bureau, which is staffed by fingerprint experts and fingerprint technicians. Experts and technicians will examine the fingerprints and match it against what they have on record to see if the person has previous convictions. If the person has no previous convictions, then a new file is created for this person. File is created both electronically and physically. We have a responsibility to secure these files because know that a criminal conviction stands in the way of persons seeking opportunities elsewhere or locally. Therefore, we have to protect these files so that corruption does not come into play. So these files are stored, the physical files are stored in a secure location while our electronic database is secured by software. So our electronic database is called Cyclops for short, or Cyclosis. This is a software developed by Jeff Smith and Associates, located in England. What this system allows us to do is to record convictions of persons convicted here or abroad. And also it allows us to manage these records. We can generate reports. Say we want to know how many murders were recorded on our files for the year 2022. We can search for that information, and we can even generate a spreadsheet to send out to whoever may be interested in the data. We are able to search on any field where data can be uploaded. We can search there. However, cannot search for data where it is not expected to be. So we cannot search for a date of birth in the name field. We can also check on what users have been doing. Each user has to log in with a password, with a username and a password. And we can see what each user does on the system on a daily basis. And that is for the Criminal Records Office electronic database. Right. Fingerprints are also stored on an electronic database as well as physically, because as you would have heard earlier, fingerprints are sent to the Criminal Records Office on the fingerprint form. And these forms have to be filed based on the classification assigned by the fingerprint expert. So the electronic database for the fingerprints is known as MBIS. And this is operated by fingerprint experts and technicians. And I'm not quite familiar with this system because I don't work with it, but briefly, it allows for the storage of fingerprints and the matching of fingerprints. And I can tell you that it gives result in a very, very short time. So that is it for the creation of the criminal records. It may take some time, but it is really, it's a short process if it was to be done on an individual basis. Now we move on to the expungement process. Persons who have convictions want to move on with their lives. They consider themselves rehabilitated, and so they want to get rid of an obstacle, which is a conviction, because we know that if persons are convicted, then certain employers will not want to take them on, or embassies will want to take a second look at them. What's the expungement process work? Wow, it seems as if I'm missing some data here. Records Rehabilitation of Offenders Act came into being in 1988, and it allows for persons who have been convicted and who have completed the relevant rehabilitation period to apply for this conviction to be expunged, meaning that it is removed from the records. And if this person applies for a police record, then they will be issued with a clean police record. The conviction will not feature. However, there are cases, circumstances under which the convicted person must disclose the conviction, whether or not it is expunged. So if a person is seeking to be employed in the government service, then he or she is required to disclose the conviction. Also, at the Criminal Records Office cannot disclose the conviction, but the individual is required to. There's a fine of $1 million for disclosure of any such expunged convictions. Persons, according to the first schedule of the Criminal Records Rehabilitation of Offenders Act, persons seeking to enter into the field of law, dentistry, medicine, midwifery, pharmaceuticals, or even teachers or vets, they are required to disclose any convictions that they have, whether or not it is spent or whether or not it has been expunged. Also, persons seeking employment in financial institutions, they are required to disclose these convictions. Persons seeking to enter the judiciary, civil service, military service, be it as a soldier or a civilian, police department, nursing homes, private or otherwise, they are required to disclose these convictions. Can apply for expungement. Expungement service is available only to persons who have been convicted of minor offenses that attract non-custodial sentences, in that they're not sent to prison, or sentences up to 3 years or 5, I think it is 5 years. What happens when a conviction is expunged? The conviction is removed from the person's record, meaning that us at the Criminal Records Office have to remove the physical file from our main collection. We will have to ensure that this file cannot be located by anyone. So it is removed from its physical location. It is removed from our electronic system, and anything that will lead you to that file, we would remove them. We had an indexing system that we previously used for the physical files. We have to remove the index card. So all tracks to that file have to be removed. And as we said earlier, if a person applies for a police record, a police certificate, it's not denied because we have to disregard the conviction. If the person goes before the court again, then we cannot tell the court of the conviction because it has been expunged. Right. So we spoke of the rehabilitation period earlier. And after the act was amended in 2014, the periods were changed. I think it stopped before 2014. The maximum sentence to be considered was 3 years. However, in 2014, it was changed to 5 years. So where the sentence imposed does not include imprisonment, for instance, the person was given a suspended sentence, or he was admonished or discharged, or he was given a fine, the rehabilitation period commences after the person has complied with the conditions of the sentence, and it is for 3 years. So if the person was suspended from driving for 1 year, that rehabilitation period begins after the 1 year suspension. If the person was given 40 hours community service, then that rehabilitation begins after the 40 hours has been completed. We move on to 5 years, where the sentence is for 1 day to 6 months. Person has to remain conviction-free for the entire rehabilitation period. If that person is convicted within the rehabilitation period, then it would be considered that the person has breached the rehabilitation period. And for 6 months, above 6 months and below 36 months, the period is 7 years. And it is 10 years for 36 months up to 5 years. If the person is given a 6 years sentence, imprisonment, then the conviction may not be expunged. Now, persons who are convicted at a young age, say under 23, they are given a 50% discount on the rehabilitation period. So you'll see the 3 years is cut in half, 18 months, and so on and so on. Now, for persons who believe that they can continue committing offenses and having them expunged, the law was amended. The amendment to the Act in 2014 provides for a 3-strike and you're out facility. In that if a person is convicted for 3 offenses, whether or not the person would have completed the rehabilitation period between the convictions, once the person is convicted 3 times, those convictions cannot be expunged. How does a person apply for expungement? The expungement application must be done in writing. Necessarily, the applicant can cause someone to complete the form on his or her behalf, but it must be done in writing in duplicates. The person should know when they qualify for expungement, for the conviction to be expunged. They can either go by the Ministry of Justice office at 51 Constant Spring Road or their website at moj.gov.jm and obtain the application forms. On completing the application form, it must be returned to the customer service desk at the Ministry of Justice, along with the fingerprint impressions. Now, the fingerprint impression can be done at any police station. So if a person is applying for his or her conviction to be expunged, they can complete the form, walk into any police station, and ask to be fingerprinted. If they are in the vicinity of 56 Duke Street, where the Criminal Records Office is located, they can have their fingerprints done there. Now, the Criminal Records Rehabilitation of Offenders Board is established by the Criminal Records Rehabilitation of Offenders Act, and it is usually headed by a former High Court judge. They have to review the application of the persons, and if they think that the person is eligible to have his or her conviction expunged, they direct the person to pay a fee of $3,000 for the processing of the fingerprints, and they pay at the tax office. Or they return to the ministry with the receipts and all documents, both the application form, the receipts, and the fingerprints are dispatched to the Criminal Records Office for us to confirm what is written on the application form. If we find that the person has convictions that are not on the form, we will include that in our report to the board. Also, if we find that the person has cases still going on, we will also inform the board that the person has cases and advise that the cases are concluded before we issue our report. Now, the board wants to hear from the community about the character of the person. They want to know whether the person is considered rehabilitated or not. So the applicant needs to supply letters, 2 recommendations from references and 2 from associates. A reference can be a pastor, a school teacher, school principal, or a justice of the peace. Associates, good friend, somebody you work with, or somebody who you hang out with. Now the board will make its decision after receiving our report, also the reference, the letters from the references and associates. And they will inform the applicant in writing and also inform the Criminal Records Office. And upon receiving the approval letter from the board, we have to remove all records, remove all files, all electronic records relating to the conviction. As I said earlier, if the person applied for police certificate, is granted one, as the conviction has been expunged. Now, the expungement process is not a same-day thing. You're not expected to apply today and have it approved tomorrow, because the board meets only once per month. It may take up to a year. Some people have been lucky to have it done before. Now, if your application is rejected, or if a person's application is rejected, that's not the end of the road. Person may appeal to the board, who will consider the appeal and respond to the person in writing. If that appeal is turned down, the person has a third chance in that they can appeal to the Minister of Justice, who will rule on whether or not the person is eligible. Now, there's a time frame. It's within 60 days of the second rejection that the person has to apply to the Minister of Justice. Board went ahead and created a new form for young offenders, where they can declare that they were between 18 and I think 23. But there's a penalty attached. If the person gives false information, then it can be dragged before the court, convicted, and convicted. There are some convictions that are automatically expunged. In 2014, when the act was amended, provisions were made for certain ganja offenses to be expunged automatically. If a person was convicted for possession of a small amount of ganja and was fined $1,000 or less, then it is automatically expunged. However, if the person was sent to prison or was given community service, then that conviction is not automatically expunged. They would have to apply for it to be removed from records. Pipes and other utensils used in the smoking or other use of ganja. So like the Rastafarians who have their chalice and their pipes, they were convicted for that, then it is automatically expunged. And this provision is retroactive. So if a person was convicted in 1960, we have records dating back to those years. If a person was convicted in 1960 and was fined 10 shillings or 1 shilling, because we were using pound, shilling, and pence back then it would be automatically expunged. Smoking ganja, regardless of the sentence, whether the person was sent to prison, given a fine, given community service, this is expunged automatically. Is smoking ganja. Right. So today, if a person is found with ganja, he can still be arrested and charged. He can still be convicted. However, if the amount is less than 2 ounces, or the fine is $1,000 or less, then we are not required to record this conviction. Person is convicted for pipes or for smoking. We know that smoking in a public place is a violation of the law. Therefore, a person can be arrested for smoking ganja if he is found smoking in a public place. Or if a person is found with ganja pipe or other utensils. But take note, however, that the pipes used for smoking cocaine or any other drug, if a person is convicted for possession of those, then it will be recorded because there's no provision here for any cocaine-related offense. Now, there are some offenses that cannot be expunged, or conviction for these cannot be expunged. And these offenses are in the 3rd schedule of the Criminal Records Rehabilitation of Offenders Act. And, cannot I cannot give you all the offenses. I have a PDF document here, which I'll bring up later on. But here's an idea of some of the offenses. Murder, offenses under the Treason Felony Act. And you see the sections: malicious destruction of property, malicious injuries to property. Offenses under 37, 39, 40, 42 of the Larceny Act. And some of these offenses are like burglary, breaking and larceny, and so on. But when we look at the PDF, we will see the direct offenses. And we see that the 3rd schedule was intended to keep persons who have been convicted of the more serious offenses in order, prevent them from getting these convictions expunged. So we will look at the PDF document before we go into the questions. You can, please. Thanks. We wait for the document to be uploaded. And scroll. So we look at offenses. See the act to your left and the offenses to the right. Can you make that a little bigger for me, please? That's okay. So intending to depose the Queen's levy. Intending to depose the Queen. Well, this was written some time ago. Or levy war against the king, or inciting insurrection or rebellion, lawfully and maliciously setting fire to any dwelling house. And this is separate and apart from arson. Can scroll on for me, please. Right. We look at the Larceny Act. We see where robbery, burglary, house breaking, shop breaking, and committing a felony. So merely breaking into the house or the shop can be expunged, but once a felony, such as larceny or rape, is committed, then it may not be expunged. Being found by night, armed or in possession of housebreaking implements. Some people might see this as a minor offense, but it's a very, very serious offense. And this remains on the book. Now, there are some drugs, cocaine, opium, and so on, that if you import it into the country, or if a person imports it into the country, then, and is convicted for these, then these convictions will not be expunged. Can scroll on, please. Hold on. Right. No, go to the Firearms Act for me, please. Thanks. Now, the Firearms Act, all offenses under the Firearms Act with only two exceptions. Two exceptions. These are punishable. So these are on the third schedule. So once a person is convicted for illegal possession of firearm, shooting with intent, or even manufacturing a firearm without a license, then it remains on their records. And we know that the Firearms Act was amended recently. So those new provisions would be on the third schedule. You can scroll down for me, please. Got offenses against the Persons Act. We spoke about murder earlier. But you see that conspiring or soliciting to commit murder will remain. So persons who seek to pay contract killers to get rid of persons, other persons, if they are convicted for these offenses, then it remains with them for life. Trying to poison a person, that remains. Now, two offenses that I want us to pay attention to is child stealing and kidnapping for ransom. Do this and get convicted, it remains with that person for life. Trafficking in person is also taken seriously, and it remains on the person's criminal record for life. The Sexual Offences Act, or let us look at the Child Care and Protection Act. Selling or participating in the trafficking of any child. We see children issue being highlighted in the news in recent days. So the law is very heavy on offenses committed against children. And we look at the Sexual Offences Act, rape, marital rape, and abduction of child under 16. Those remain on a person's criminal record if he or she is convicted. And females can be convicted for sexual offenses also. The imbeciles, they are protected here, right? Child pornography is something that is taken seriously also. So persons who have these things on their phones, if they are convicted, then it remains with them. Just scamming, that remains with a person who is convicted for it. Also, any person convicted under the Terrorism Prevention Act. And we will not go through the entire list, but it is there for whoever requires a copy. So we move into questions now.
Good morning again, Detective Sergeant. That was a very informative presentation. I am seeing one question so far in the chat. It comes from Daniel Meek, who asks, would it be dishonest if someone whose conviction was previously expunged indicates on a form that he or she has no previous arrest or criminal convictions?
That is the question that the question that we have to ask, that we have to answer quite regularly. But if you are required to disclose the conviction, then you must disclose it, because you can be charged for not disclosing it once the law requires you to disclose it. However, this is my opinion, I would not consider it dishonesty if you do not disclose it, if you are not required to.
Thank you. I'm not seeing any further questions in the chat, but just for my personal edification, and for the benefit of the listeners as well, in circumstances where the expungement application was not completed properly or had the supporting or relevant documents attached to it, could you say what the effect would be on the length of time that the process takes?
Us at the Criminal Records Office will usually reach out to the applicant, try to get these documents out of our office in the shortest possible time. I am of the opinion that the Ministry of Justice is very efficient and they will reach out to the applicants also. So if there's any missing information or missing document, then the applicant would be contacted and asked to supply the information.
Thank you. I think as well that an important piece of information that you gave during your presentation, as in it was generally important and informative, but in terms of a practical application, when you indicated that the fingerprints can be done or obtained at any police station, there's a misconception that you have to go to Duke Street.
Correct. That's correct.
I'm sure that that adds to the pressure that office faces. So it's a good takeaway for anybody who is interested in getting this process underway to know that they can, utilize the police stations around the island.
Just about any police station. Because the thing is, you cannot give someone else's fingerprints to process your application. It has to be your fingerprints.
Yes.
Because when we get the fingerprints, we match it against what we have on file. So if X is applying for his convictions to be expunged, then it would serve no purpose for him to present another person's fingerprints. So you can have your fingerprints taken at any police station.
Okay. Well, given the comprehensive manner in which you dealt with the topic, in terms of walking us through from the very creation of the offense to the categories of offenses that can be expunged to the categories that cannot be expunged, I believe that is why we're not seeing many questions coming in, because a lot of the problem areas would have been covered by your presentation. So in those circumstances, I am going to ask Ms. Kayla Sturridge, who is a student here at the Norman Manley Law School, to do the vote of thanks at this time.
A pleasant morning to you, Detective Sergeant Leston Ferguson. Good morning, colleagues. Good morning, tutors, members of the Legal Aid Clinic, and all other members who are participating in the Norman Manley Law School Legal Aid Fair today. Detective Sergeant Ferguson, we appreciate and recognize that with all the occurrences in Jamaica, you must be extremely booked and busy. And so, on behalf of the Norman Manley Law School Legal Aid Fair, I would really like to thank you for taking the time out of your schedule to not only attend our fair, but also to prepare and share information which has been beneficial to us as law students, attorneys, and the general public. We are appreciative to have been given the opportunity to learn more information about the criminal law system from your presentation, especially since you have amassed years of experience and expertise in the field. We look forward to using this knowledge in classes, in practice, and through the general education of others. Thank you once more.
You're most welcome, ma'am.
Thank you, Ms. Sturridge. Very well said. Detective Sergeant, before I release you, I see a question coming in the chat, and I would really want them to have the benefit of your answer. It comes from Debbie Sharp Gray, and she asks, are fingerprints for an application for police record held by the Criminal Records Office, and for how long, if at all?
Law doesn't allow us to keep fingerprints of unconvicted persons. Therefore, these fingerprints are destroyed within a reasonable period of time. Sometimes it depends on availability of resources. However, these fingerprints are not added to our criminal database and will not be used for anything else. As a matter of fact, these days, we scan fingerprints. We don't take physical fingerprints unless we are going to do a manual comparison. Fingerprints are scanned by our ILS machines, and it is matched electronically. So we will only take a set of fingerprints if we have to do the manual processing.
Okay, well, I want to thank you again, Detective. It has been a personal education moderating the session. And I'm sure that the audience has also taken away a lot, even based on the feedback obtained from the vote of thanks and the questions that have come in. We really do appreciate your time. And just to advise those still on the platform with us that the next broadcast, the next session will begin at 11 a.m. So we are looking forward to having you again at 11 for that session. Thank you.
You too.